Hello friends, welcome to my channel, Net Charity. In the education series, today, CA Shri Vipin Batavia, eminent speaker on charitable organization gives his insight on the topic, verdict of Mumbai High Court on Writ petition number 7587 of 2026, on irrevocable clause, in the objects of NPOs and cancellation of registration U.S. 12 AB and ATG for income tax exemption of the charitable organizations. Before going further, let me request you that if you like the video, kindly like, subscribe and share the channel. This will be a gratitude towards the speaker. Let's start.
Friends, today I want to explain the provisions applicable to income tax registration under section 12A and ATG approval applicable to charitable trusts, institutions commonly known as NPOs, including recent developments and the recent Bombay High Court judgment in the case of Writ petition number 7587 of 2026 in the case of Chamber of Tax Consultants, Bombay Chartered Accountants Society and other few charitable trusts versus CIT exemption Mumbai, Principal Chief CIT Delhi, CBDT and Union of India. Friends, you are aware that income tax registration provisions applicable to charitable trusts, NPOs, are drastically amended by Finance Act 2021 with effect from 1/4/21. The 12A was amended, 12AA was replaced by section 12AB. Earlier, the registration were granted perpetual. But after this amendment, now the registration and approval ATG are restricted to 5 years. And one new concept of provisional registration was also brought in. This provisional registration can be obtained by the trust which has not started or commenced their activities, so that they can have that registration and they can commence their activities thereafter. And there are time limits within 6 months from the commencement of activity or prior to 6 months of the expiry of the date, they have to apply for renewal of registration. The re-registration were required after the amendment in 2021. All the trusts were required to file Form 10A along with the basic informations or basic documents were required to file along with the old registration certificate. Those who were granted registration by CPC, centrally allotting URN, unique registration number, to all the trusts, and were granted a registration from assessment year 22-23 to 26-27. It means the registration were expiring on 31/3/2026. As per provision, all the trusts were required to file an application in Form 10AB at least 6 months prior to expiry of the date, and the date was falling on 30th September 2026. Meantime, there were provisions were brought in. The CIT exemption was authorized to condone the delay for making such applications. And if the applications condoned, then in that case, the application will be considered as if it is filed in time. Thereafter, there was a relief granted for small trusts, wherein the registration now can be obtained for 10 years in place of 5 years, and that there was a condition that those trusts which were having their turnover or gross receipts less than 5 crore, and in earlier 2 previous years their receipts are less than 5 crores. But at the same time, there was no amendment in the ATG provisions for condonation, as well as granting the registration or approval for 10 years. Therefore, now the small trusts are getting income tax registration for 10 years, but ATG they are granting for 5 years. After applications were filed, the income tax department started sending the notices calling for details. Very short time was given to submit those details. Whether the trust deed contains irrevocability clause and dissolution clause. It is known to all that the old trusts, particularly old trusts, we are not having such clauses in their deeds. So either they have to get their trust deed amended, and they were good enough that if you submit the application after passing the due, completing the due procedures before the Charity Commissioner Mumbai, and they were granting the registration. But to obtain or to change the trust deed is a very cumbersome process. It takes longer time. Even preparing application and submitting, because it requires many procedures to be followed. And we tried to resolve this issue with the department, but could not succeed. Another point was, in Form 10AB, the application for renewal of registration, at question number 6, it was written that whether your trust deed contains irrevocability clause. And the answer was drop-down selection, that was either yes or no. So where the trusts were clicking for the no, the application was not moving forward. Therefore, they were forced to, I repeat it, they were forced to click yes. And they have submitted the applications. With this, the trust or applicants have started getting the notices. Many details were asked. Thereafter, they realized that certain irrelevant details are asking. They reduced that notice size, and the details were asked only for the relevant requirements. But after that, they started rejecting the renewal application on the ground that your trust deed doesn't contain irrevocability and dissolution clause. There were certain more rejections who could not submit their details in time, or could not submit for a month or so, or 1.5 months. They started rejecting those applications also on the ground of non-compliance, without giving the opportunity of show cause notice. In this situation, the writ petition was filed before Bombay High Court, wherein the Bombay High Court has pronounced the order on 9th of March 26, and the order was uploaded on 18th of March, that is yesterday. The summary of the order is: the respondent shall refrain from rejecting the renewal applications under section 12AB solely on the ground of absence of irrevocability and dissolution clause in the trust deed. So now High Court has ordered that rejection should not be done if there is no such clauses. They have explained, it's a very lengthy judgment of I think it is 48 pages judgment. So details can be read and very interesting, very good judgment it is. Speaking judgment. Second, they have said that they shall not treat yes as furnishing false or incorrect information, constituting specified violation. Because in the rejection order they were saying that it's a specified violation because as per the provision, if you submit in the application any incorrect or false information, it is falling under definition of specified violation, and any specified violation, the CIT has power to proceed for cancellation of registration of that trust. So the High Court has said it is not to be treated because they were forced to write yes. Second thing is that they have quashed the orders passed for rejecting on this ground of the petitioner's trusts as well as all those trusts whose registration application have been rejected on this very ground. And they have further said the Income Tax Department has to pass those orders within 6 months, within 6 weeks from today. Means the date on which they have pronounced the order in the court, that is 9th of March. Secondly, they have said the question number 6 in Form 10 AB should be modified to read it, is the trust institution revocable? Instead of asking irrevocable word in irrevocable trust, the question is now to be replaced or modified by whether the trust deed of the trust or institutions contains revocable clause. So this is a very good judgment. Not only that, they have said Form 10A and Form 10B also to be framed in such a way that correct information without being forced, they should provide correct information without being forced to make incorrect declaration. Means the form should be framed in such a manner that one has not to give the wrong information. Purposely it is given, for that those amendments are there. The petitioner's applications were rejected, were also caused, and also all consequential orders passed for denying ATG on the same ground for which the 12A was rejected, 10AB form is rejected, those are also quashed and set aside. So now the Income Tax Department has to relook those orders and pass the orders accordingly within the 6 weeks' time. All such cause applications shall be decided fresh within 6 months' time. And it is further mentioned that any order so passed shall be deemed to have come into effect from 1st April 2026 because the ATG approval is granted from the day on which the order is passed, or it is applicable from the day. So High Court has said no, it is to be treated at 1/4 because they are already having the ATG approval till 31st March. 12A registration is granted by assessment wise. So that assessment year 26, 27, 28 onwards for 5 years or 10 years as the case may be. Friend, this is the summary of the High Court judgment which I wanted to cover here. Moreover, CIT exemption has power to decide the cases on the basis of merits, but he has to see for renewal of registration, genuinity of the activities conducted by the trust, and they have complied with all other laws applicable to them for the purpose of achieving the objects of the trust. So those conditions, those merits are still there. So they should decide on the basis of those merits and accordingly make the orders. Friends, I hope I have explained in short, in nearly 15-16 minutes, about the basic provisions and the recent Bombay High Court judgment, which will help all of you. If you have got any question, any query, you can ask me. I am CA Vipin Batavia. My contact number is 9820046492. Thank you. Thank you very much. And all the best to all of you.